Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 recurring issues in trade secrets injunction cases. What's a trade secret injunction case? Well, let me give you a common scenario as an example. Let's say a disgruntled employee leaves her employer and goes to work for a competing company and takes company documents with her. The first company is going to claim that those documents contain its trade secrets, and in most cases, it's going to ask the court for a temporary restraining order or a temporary injunction or preliminary injunction, depending on whether it's state or federal court. And they're going to ask that the injunction bar that employee from using those trade secrets and going to work for the competing company. My number 5 recurring issue in trade secrets injunction cases is whether a contractual stipulation to an injunction is enforceable and binding on the court. In a lot of cases, the employee will have signed an employment agreement that contains all kinds of stipulations that are, of course, beneficial to the employer. One of those might be a contractual provision that says if the employee takes the company's trade secrets, then the company will be entitled to an injunction from the court. So does the court have to follow that? Well, there are 3 different views among Texas courts. One view is that yes, that's enforceable. If the contract says the company gets an injunction, then they get an injunction. I think that's the minority view. The middle ground view sort of punts on this issue and says, well, it's not necessarily binding on the court. It's just a factor to be considered. That gives the court some wiggle room to kind of do whatever it wants. And finally, some courts take the view that a contractual stipulation that the company is entitled to an injunction just has no effect whatsoever. The idea is that private parties can't agree between themselves how courts are going to decide cases. And just personally, I think the third view is correct, unless I'm the one arguing for the injunction. Number 4, does misappropriation of trade secrets create a presumption of irreparable injury? That's a mouthful, so let me break that down a little bit. When the first employer goes to court to try to get an injunction against the employee who has left and taken trade secrets to a second company, one of the common law requirements for getting an injunction is irreparable injury, which means injury that cannot be adequately compensated by damages. Some Texas courts have said that if the first employer proves that the employee has taken or used the company's trade secrets, that creates a presumption of irreparable injury. Now, side note here, these courts are usually not very clear on whether that's a conclusive presumption or a rebuttable presumption. I would argue it's rebuttable. But in any case, you can expect that the employer's counsel is going to cite that presumption of irreparable injury. On the other hand, there is a recent Texas Supreme Court case called Pike that suggests perhaps misappropriation of trade secrets does not create a presumption of irreparable injury. In that case, a jury found that the defendant misappropriated trade secrets. Nonetheless, the Texas Supreme Court held that the plaintiff employer was not entitled to an injunction. That suggests to me that this presumption of irreparable injury may not be valid. Number 3, the inevitable disclosure doctrine. You've probably heard about it. What is it? It's basically the idea that if a former employee of a company knows the company's trade secrets and is going to work for a competing company, that you can get an injunction to stop that employee on the theory that the employee will inevitably disclose the company's trade secrets while working for the competitor. Texas courts have been reluctant to expressly adopt this doctrine, but you can find Texas opinions that support the concept. They will say things like an employee who possesses a company's confidential information and is in a position to use it, that fact is enough to establish the imminent harm that is necessary to get an injunction. On the other hand, you can find other Texas cases that say the mere fact that an employee has the company's trade secrets or knows the company's trade secrets is not by itself enough to establish the company's right to an injunction. Number 2 is the price undercutting theory. This is the idea that when an employee leaves a company and has knowledge of the company's prices, she can use that knowledge to go to a competing company and then steal customers by slightly undercutting the first company on price. You see this scenario a lot, but are the prices actually trade secrets? This is a fact-intensive issue, and you can find Texas opinions going both ways. There's a recent case out of the Austin Court of Appeals that looks at the price undercutting issue with some skepticism. In that case, the court noted that the customers of the first company were free to share those prices with anybody. And so the court looked at that and said that amounted to public disclosure of the prices, and so they could not be trade secrets. And finally, the number 1 recurring issue in trade secrets injunction cases: is a customer list a trade secret? The answer, of course, is it depends. A customer list can be a trade secret. In fact, the Texas Trade Secrets statute expressly refers to customer lists as one of the types of information that can be a trade secret, but it still has to meet all the elements of the trade secret statute. So you will get some cases saying that a customer list was a trade secret and some cases saying that it was not. Again, like prices, it tends to be a fact-intensive issue. So those are my top 5 recurring issues in trade secrets injunction cases. I hope that was helpful. If you'd like more information and more case sites, I recommend going to my blog at 5minutelaw.com. I've got posts on each one of the issues I talked about in this video. If you like the video, hey, please hit the like button, or even better, share this with someone you know. And hey, thanks for watching.